Intellectual property. What is intellectual property? Intellectual property refers to creations of the mind, such as inventions, literary and artistic works, designs and symbols, names, and images used in commerce. Intellectual property, or IP, encompasses a wide range of creations of the mind. This term is used to describe the legal rights that creators have over their intellectual and artistic works. Here are the main types of intellectual property: the copyright, patents, trademarks, and trade secrets. Now let's have a look into intellectual properties one by one. Now we have the copyright. This is a legal term used to describe the rights that creators have over their literary and artistic works. It is an exclusive right to distribute, display, perform, or reproduce an original work in copies. Patents are exclusive rights granted for an invention. A patent provides the patent owner with the right to decide how or whether the invention can be used by others. Trademarks. A trademark is a distinctive sign that identifies certain goods or services produced or provided by an individual or a company. Its origin dates back to ancient times when craftsmen reproduced their signatures or marks on their artistic works or products of a functional or practical nature. Trade secrets. These are confidential pieces of information that provide a company with a competitive edge and may include manufacturing or industrial secrets and commercial secrets. Intellectual property plays a crucial role in our daily lives and in the development of the global economy. The fair use doctrine establishes it has 4 factors. Let's have a look to these 4 factors. Purpose. Number 1, purpose and character of the use. This factor examines the purpose and character of the use, including whether it is transformative or adds something new and original to the original work. Non-commercial, educational, or commentary uses are often considered more likely to the fair use. Number 2, nature of the copyrighted work. This factor looks at the nature of the copyrighted work itself. Factual or informational works may be more susceptible or fair use than highly creative or fictional works. Amount and substantially of the portion used. This factor considers the quantity and quality of the copyrighted material used in relation to the whole work. Using a small or insignificant portion of the work may be more likely to be considered fair use. Number 4, effect of the use of the market value of the copyrighted work. This factor examines the potential impact of the use on the market value or potential market for the copyrighted work. If the use would harm the potential market or value of the original work, it may weigh against fair use. The Prioritizing Resources and Organization for Intellectual Property, or Pro-IP Act of 2008 increased trademark and copyrighted enforcement. The Pro-IP Act was enacted in the United States to enhance intellectual property enforcement and protection. It aimed to strengthen trademarks and copyright enforcement by implementing various measures. Some key provisions of the Pro-IP Act include increased civil and criminal penalties, establishments of Intellectual Property Enforcement Coordinator, or IPEC, creation of the Intellectual Property Enforcement Division, or IPED, and civil asset forfeiture.
The original GATT was established to promote international trade and reduce trade barriers among member countries. As part of its evolution, the GATT was replaced by the WTO in Geneva, Switzerland. The WTO was created to enforce compliance with trade agreements and resolve trade disputes between member countries. Within the framework of the WTO, there is a section called the Agreement on Trade-Related Aspects of Intellectual Property Rights. This agreement focuses on intellectual property rights, including copyrights. It aims to establish standards and regulations for the protection of intellectual property in the international trade. The World Trade Organization is an international organization that focuses on establishing and enforcing rules for international trade. These rules are outlined in the World Trade Organization agreements, which are negotiated and signed by representatives from various trading nations around the world. The primary objective of the World Trade Organization is to facilitate the smooth conduct of business for producers of goods and services, as well as exporters and importers. By providing a framework for trade, the WTO aims to promote fair and predictable global commerce. The World Intellectual Property Organization is a specialized agency of the United Nations that is specifically focuses on intellectual property. World Intellectual Property Organization primary mission is to promote and utilize intellectual property as a means to encourage and foster innovation and creativity worldwide. Intellectual property refers to intangible assets such as inventions, trademarks, copyrights, and design, which are protected by legal frameworks to provide exclusive rights to their creators or owners. WIPO plays a crucial role in developing international IP policies, providing services to protect IP across borders, resolving IP disputes, facilitating the exchange of IP-related knowledge, and promoting the use of IP for economic, social, and cultural development. By serving as a global forum and reference source for IP information, WIPO aims to create a balanced and effective international IP system that benefits all stakeholders, including governments, businesses, and society as well. The Digital Millennium Copyright Act is a legislation that was enacted in 1998 in the United States. One of the main purposes of the DMCA is to implement two treaties established by the World Intellectual Property Organization or WIPO at an international level. The DMCA addresses various aspects related to copyright protection in the digital age. One important provision of the DMCA is that it makes it illegal to circumvent or bypass technical protection measures that are used to safeguard copyright works. This means that it is unlawful to circumvent digital locks, encryption, or other technological measures that control access to protected works. The Digital Millennium Copyright Act has been a subject of debate and differing opinions regarding its impact on the growth of the internet and the powers it grants to copyright holders. Supporters of the DMCA argue that it has played a crucial role in fostering innovation and freedom of expression on the internet. They believe that the DMCA safe harbor provisions, which protect internet service providers from liability for the action of their users, have allowed online platforms to thrive and provide a space for user-generated content. These supporters argue that without these protections, online intermediaries would face significant legal risks, still fleeing their ability to host and share users-generated material. A patent is a legal grant of property rights that is issued by the United States Patent and Trademark Office to an inventor. This grant gives the inventor the exclusive right to prevent others from making, using, or selling the protected invention without their permission. In other words, a patent provides the inventor with a monopoly over the invention of a limited period of time. In order for an invention to be eligible for a patent, it must satisfy several key criteria. The invention must be useful, meaning it must a practical utility or serve a specific purpose. This requirement ensures that patents are granted to inventions that offers tangible benefits or provide solution to real-world problems. Utility patents, which cover the majority of patented inventions, require a demonstrated usefulness. Furthermore, the invention must be novel, which means it must be new or not previously known or publicly disclosed before the filing date of the patent application. This requirement prevents the granting of patents for inventions that have already been made available to the public, ensuring that patents are awarded to truly new and inventive concepts. Lastly, the invention must not be of use to a person with ordinary skills in the same field. This means that the invention should involve a inventive step or a level of creativity that would not be of use to someone knowledgeable in the relevant field. The non-obviousness requirements aims to reward and protect inventions that represent significant advancements or departures from existing knowledge or technology. The Lee-Smith American Invents Act, passed in 2011, introduced notable reforms to the U.S. patent system. One significant change was the transition from a first-to-invent system to a first-inventor to file system. Under the previous system, the first person to invent an invention had priority in obtaining a patent. However, with the AIA, priority shifted to the first inventor to file a patent application, regardless of who actually invented it first. This change brought the U.S. patent system in line with the majority of other countries. Additionally, the AIA expanded the definition of prior art, which refers to publicly available information used to determine the novelty and patentability of an invention. The expanded definition now includes not only prior patents and published patents application, but also certain public uses, sales, and disclosures. This broader scope of prior art makes it more challenging for inventors to establish the novelty and non-obviousness of their inventions, thus raising the bar for obtaining a patent.
What is the difference between copyright infringement and patent infringement? Patent infringement involves the unauthorized use of patented invention. This invention can be the new useful process, machine manufacture, or composition of the matter of the new and the useful improvement. The copyright infringement, on the other hand, relates to unauthorized use of the original works of authorship. The Court of the U.S. Patent and Trademark Office have changed their attitudes the option of the patenting of the software over the years. The United States Patent and Trademark Office, USPT or Office, is an agency of the U.S. Department of Commerce. The role of the USPTO is to grant patents for the protection of invention and to register trademarks. What is the Economic Espionage Act and Defend the Trade Secrets Act? Amends 18 U.S.C. 1836, the Economic Espionage Act, to establish the Federal Private Service civil cause of the action, the misappropriation of a trade secret. In some situations, reverse the engineering might be considered unethical because it enables access to information that other organizations have cooperated or classified as a trade secret. Reverse the engineering can sometimes lead to the unauthorized access to proprietary information which could breach copyright or violated trade secret. Is a crucial or considered ethical implication in the illegal boundaries with engaged as activities. One key aspect to consider the Digital Millennium Copyright Act, the DMCA, which includes the provision that makes it illegal to circumvent technology measure the control access. This means that if the software or product is protected by access control, attempting to reverse engineering to bypass these controls could potentially violate the DMCA. In additional to the DMS software license agreements obtained include clauses that capacity prohibit reverse engineering. Violating these clauses can lead to illegal consequences, including the potentiality lawsuit for the unequal property infringement. The open source model encourages the community involvement, enable the diverse group of programmers to contribute the improvement of the software. This collaborative approach often leads to a more robust, secure, the innovative solution as developers from around the world can work together to enhance the code base. One of the significant advantage to open source software is its adaptability. Users have the freedom of modifying the code of the suite there are specific needs or address the shortcomings in the original software. This flexibility allows the customization making the open source software a popular choices for the many organizations and individuals. In contrast, industrial espionage involves the use of unethical or illegal methods to obtain the confidentiality business information that is not publicly available. This can include the activities like hacking into computer systems, stealing trade secret, or briefing employees to disclose sensitive information.
One key aspect to consider is that Digital Millennium Copyright Act (DMCA), which include provisions that make it illegal to circumvent technological measures that control access to copyright works. It means that if a software or product is protected by access control, attempting to reverse engineer it to bypass this control could potentially violate the DMCA. In addition to the DMCA software license agreement often include clauses that implicitly prohibit reverse engineering. Violating these clauses can lead to legal consequences, including potential lawsuit for intellectual property infringement. The open source model encourages community involvement, enabling a diverse group of programmers to contribution to the improvement of software. This collaborative approach often leads to more robust, secure, and innovative solutions as developed from around the world and work together to extend the code base. One of the significant advantages of open source software is its adaptability. Users had the freedom to modify the code to suit their specific need or address any shortcoming in the original software. This flexibility allows for customization and optimization, making open source software a popular choice for many organizations and individuals. In contrast, industrial involve the use of unethical or illegal methods to obtain confidential business information that is not publicly available. This can include activities such as hacking into computer systems, stealing secret or dribbling employees to disclose sensitive information. In the United States, industrial espionage is considered as a serious crime that is punishable by law. Engaging in illegal activities to gain a competitive advantage is not only unethical but can also result in reverse legal consequences, including heavy penalties, fine, and even imprisonment. Absolute maintaining ethical standard is essential for competitive intelligence analysis. Engaging in unethical or illegal behavior can not only damage the reputation of the analyst and the company but also lead to illegal consequences. Lying or misrepresentation when gathering information can undermine the credibility of the analysis and the integrity of the intelligence gathered. It is important to be transparent and honest in all interaction to maintain trust with source and stakeholders. Avoid using someone else's trademark. Website owner should not use trademarks belonging to others in the way that may cause confusion among customers regarding the source of the product or service being offered. Obtain prior authorization if website owner want to be used the third-party trademark in any way, such as their product description, advertising, or domains name that should obtain permission from the trademark owner. Good license agreement or other legal means. Overall, cyber squatting is deceptive practice that can harm legitimate trademark owner and confuse customers. By being vigilant, enforcing the rights, and taking proactive measures to safeguard their intellectual property, trademark owners can be defended against cyber squatting and prevents the integrity of their brands in the digital landscape.